Ladies and gentlemen, I seem to have about 4 most distinguished visitors here today, visitors, great supporters of this movement, lawyers, and we want to hear from them. I'm going to call Guy Goodwin Gill. There he is, thank you, who is a distinguished professor, Oxford, and an expert in refugee matters and international affairs.
I am one of the legal team that's been trying to use legal pathways to clear the way to a peaceful and humanitarian solution for those in Ashraf. It's regrettable that the present government of Iraq has stepped so determinedly beyond the goals which the UN Security Council set for it to return to full membership of the UN: democratic government, protection of human rights, respect for the rule of law. And it's no less regrettable, in my view, that the United Nations, whether it's represented by the Special Representative of the Secretary General, by the UN Assistance Mission in Iraq, UNAMI, or the UN High Commissioner for Human Rights, or the UN High Commissioner for Refugees, it's regrettable that the UN, too, seems to be unwilling to remind the government of Iraq of its obligations, its legal obligations as a member state, and to press for their full implementation in good faith. There are, in fact, not just humanitarian aspects to this issue. There are many legal dimensions to the plight of the residents of Ashraf. Ashraf, now described, I saw recently, as a city by the government of Iraq, but without reference to those who built it. As refugees, as applicants for recognition of refugee status, the residents of Ashraf are clearly entitled to international protection, which means they must be protected from forcible return to their country of origin to the risk of persecution. But as long-term and lawful residents, and let's not forget they entered Iraq lawfully and were for many years lawfully resident there, as long-term and lawful residents, they are entitled not to be forcibly displaced within Iraq, even and notwithstanding the decision of the government of that country that they should now seek residence elsewhere. As foreign nationals, they are also entitled to compensation for loss and damage to their personal effects, for loss of their investment in the city of Ashraf. And simply as individual human beings, they are entitled to the effective protection of their human rights. And Iraq, the liberated, newly democratic Iraq, is of course bound by international law, by customary international law. But Iraq has also freely chosen to ratify and be bound by one of the most important universal human rights treaties, the 1966 International Covenant on Civil and Political Rights. And no matter where you are, implementation and enforcement of human rights obligations, as we know, can present challenges. But one thing is sure, if no one takes up obligations, if no one mentions violations and the threat of violations, then nothing will change. And the evidence before us today, I think, allows the reasonable inference that the residents of Ashraf are at imminent risk of yet further violations of their human rights. Let us just take 2. And let us for the moment put to one side the potential international criminal liability of individual Iraqi power holders. That's, I think, an issue for another day. But let me focus on just 2 protected rights, which I see particularly important in the immediate context, and they're set out quite clearly in the 1966 Covenant. The first being freedom of movement, protected by Article 12. The second being freedom from arbitrary detention, protected by Article 9. As I said a moment ago, it's undisputed that the residents of Ashraf entered Iraq lawfully. It's undisputed that they've resided there lawfully for many years. They are therefore entitled, as a matter of law, to freedom of movement. And in the context of the 66th Covenant, that means coming within paragraph 3 of Article 12. And I think it's important also to remember, as the Human Rights Committee recalled many years ago, that freedom of movement in any case includes, and I quote, protection from all forms of forced internal displacement. So any restrictions, moreover, must be provided by law, they must be necessary and proportionate and consistent with all other covenant rights. This means, of course, that restrictions on freedom of movement must not amount to arbitrary detention, to an impermissible deprivation of liberty and security of the person, contrary to Article 9 of the Covenant. And we know, sadly, enough about what's going on now in Camp Liberty to understand that what is being constructed is not a transit camp, it's not a refugee settlement, it's a detention centre, a prison. And knowing what we know about the proposed construction, about the living conditions, I use the word living somewhat ironically, what we know about the absence even of the forms of legality, the possibility of legal redress, the only reasonable conclusion, I suggest, is that here is being prepared the means of arbitrary detention and who knows what other violations of human rights. Now, the United Nations itself is committed to the rule of law. There is indeed a rule of law unit in New York. It's committed to the prevention of atrocity, of abuses of human rights. It can hardly, I suggest, be party to this process of consigning the residents of Ashraf to such restrictions on freedom of movement as to amount to arbitrary detention. On the contrary, the UN must take a stand for rights, not only in its relations with the government of Iraq, but also as a matter of organizational policy vis-à-vis other states members of the UN. And sadly, we hear little enough, in the words of the United Nations and its representative agencies, of human rights in this context. And so I think it's particularly worth recalling what the International Court of Justice itself had to say in 1980, in a case with which many may well be familiar by name alone, the Iranian hostages case. The International Court of Justice said, and I quote, "Wrongfully to deprive human beings of their freedom and to subject them to physical constraint in conditions of hardship is in itself manifestly incompatible with the principles of the Charter of the United Nations, as well as with the fundamental principles enunciated in the Universal Declaration of Human Rights." And I don't think any authority could have put it better. Thank you, Madam Chair.